May it please your lordship.
Yes.
My lord, item number 6 to 9.
Mm.
Perhaps your lordships cannot take up the matter. Lord, lordship appeared for some of the petitioners for Tominete,
Okay, okay.
then Sauhing, Tayang and all.
Oh,
My lord, we pray it may come after 4 in the new year, my lord. After 4
6 to?
6 to 9.
Okay.
Otherwise, my lord, matter will be again listed, then we'll have to make a mention. That's why we thought we must inform your lordship.
Right, right. So, then, like to say that list this matter without me.
Yes.
Okay,
And as per the joint prayer, middle after 4 weeks.
okay. List this matter before any other bench without me, staff. And on the joint prayer made by both the Lari Council for the appearing on behalf of the parties. When
After 4 weeks.
okay, let this matter be listed after 4 weeks. Okay.
My lord, then this item number, my lord, 14 to 18, my lord. 14 to 18, my lord.
14 to 18.
In this case, my lord, as you lord, you got it, my lord.
Yes, sir.
Item number 14 to 18, my lord.
Yes.
My lord, here we need some more time to file affidavit, my lord.
Affidavit.
Affidavit, my lord.
My lord, I am appearing for the petitioner in all these cases. May I pray for 2nd of February, my lord?
2nd of February.
Yes.
Okay. Okay, Mr. Harith Nabam, Learned Additional AG, for the state respondent, prays for further
My lord,
time
second
to
Feb-
file affidavit in opposition.
More than
Staff.
3
More than 3 weeks.
More than?
But it's
2nd February will be more than 5 weeks.
More than 5 weeks. Okay, some more time. Okay. Okay. As prayed for by both the Lani Council for the parties, let this matter be listed on 2nd February.
2nd
Feb,
February.
yes.
2nd February. Second week or second?
2nd February.
2nd February. Okay.
And my lord, the interim orders passed earlier will continue.
The interim order passed earlier shall continue till the
In all
next
the
date of
cases.
listing. Okay, in all the cases.
Yes.
all right.
Okay.
Kind indulgence to item 23 to 25, my lord.
23 to 25.
I need to file rejoinder in this matter, and as consented to by other parties, may I request this matter may be listed on 16th of February, my lord.
Okay.
My lord, 16 would be too far because the project has been brought to a standstill
Hmm.
in view of the interim order dated 6/6/2025.
Okay.
Mr.
Therefore-
Modri is there?
Yes. Therefore, I felt that it will be listed on, my lord, 27th of January because we have received the draft award, my lord, and by who knows, by that time we may pay the entire amount also. We may deposit the compensation.
No, but that is something we are not stalling the projects.
No, my lord,
In any
the
case.
order which says that the activities carried out by the NHPC has to be stopped.
Fine, my lord, on 2nd of February then.
27.
No, it's not possible. Mr. Senior Counsel Barbara will also join me in this case.
Okay.
Uh,
You want to file?
We want to file the counter.
Okay.
Second phase is,
Mr.
And
T.D.
then-
Tara, Lani Council for
Third,
petitioner,
fine, sir. Third.
no
prays for some time to file affidavit in reply. Staff. Mr. Ali Tongo, Lani Council for the respondent is also present.
I'm sorry, my second is not a holiday, sorry.
Okay.
25, my lord.
When?
Second,
Finally?
my lord, second February.
Second,
2nd February.
second phase. Monday.
Mr. R.S. Nabam, Lani Additional
This is.
AG is also present on behalf of the state respondent staff. On the prayer of the parties, let this matter be listed again on 2nd February. Okay.
In the meanwhile, my lord, they'll find the reply. my
I'll
lord.
find the rejoinder.
I'll say,
John.
I'll find that.
he prayed for some time, I said.
Yeah.
Okay, in the meantime, the
Sir.
petitioner shall file their rejoinder. Okay.
We're grateful. man.
May I, Your Lordship?
Yes.
Lordship, I beg to mention item 27, Your Lordship, in
That interim order may kindly be.
The interim order passed earlier shall continue till the next date of listing. Okay.
Your Lordship, item number 27,
Hmm.
I'm mentioning on behalf of N. Lawang, Senior Government Advocate. He instructed me to adjourn this matter, Your Lordship, after 2 weeks.
Have you informed the petitioner?
Yes, Your Lordship.
Okay. Ms. Pango, Land Council appearing on behalf of Mr. N. Law, Land Government Senior Advocate. Prays for adjournment of the matter. She has also obtained consent from the Land Council for the petitioner. Has prayed for, list this matter after
2 weeks, Your
2
Lordship.
weeks. Okay.
May I, Lordship? I beg
Yes.
to mention item number 21, Your Lordship, on behalf of leading counsel B. Picha. B. Picha is out of station for his medical checkup. So,
21.
yeah, 21, yes.
Here for
I'm praying on behalf of B. Picha, Your Lordship.
BP Chair.
Yes. Matter may be listed after 3 weeks, Your Lordship. We have-
Mr.
T. Tarin, Your Lordship, on behalf of B. Picha.
Some is that Mr. BP Chair, Land Council for the petitioner has some personal difficulties today. Therefore, pray for adjournment of the matter for the day. Anyone appearing on behalf of the respondent? Okay,
We have taken consent, Your
which-
Lordship.
consent from the, okay,
Other side,
to which the Land Council for the respondent has no objection. Prayer allowed. List this matter after
3 weeks, Your Lordship.
3 weeks.
Ah.
Okay,
Also, Your Lordship, item number 22. Herein, B. Picha is a leading counsel, RD standing counsel. Herein,
Okay.
we are
here, who is for the petitioner?
I'm the petitioner, madam.
Okay, you have any objection?
No.
Okay,
For respondent.
similar order, huh? Is here, but here he is appearing on behalf of the BP Chair for respondent and Land Council for the respondent. To which Mr. Udeka, Land Council for the petitioner has no objection. Prayer allowed. List this matter after 2 weeks.
3 weeks after, we have received just a affidavit in opposition. They have
3 weeks.
furnished us to rest. 3 weeks after, we will file a objection, Your Lordship.
Okay, after 3 weeks. Okay.
Yes. Oblige, Your Lordship.
Lordship, I would like to mention item number 28, Your Lordship. I've taken the consent, Your Lordship. May I kindly take up this matter after 3 weeks?
Okay. Ms. Besser, Land Government Advocate, with the consent of the Land Council for the petitioner, prays for listing this matter after 3 weeks. The prayer is allowed. List this matter after 3 weeks.
Obliged, Your
Item number 1.
May I please, Your Lordship?
Yes.
This matter is a contempt matter. My lord, for the last order, my lord, I was supposed to satisfy that whether this is coming under the limitation period or not. My lord, this matter comes under the limitation period, my lord.
Which one?
This contempt
It's
matter.
contempt petition.
Yes,
Limitation?
this is within the limitation.
Yes, yes.
So I may
Okay.
just take to the judgment. Judgment is in page 11. But then operative person is in page 185. It's the analogous matter. Matter related to the compensation.
Okay, what is the direction?
Yes, direction is in page 185. May I read 185? Direction was that they should recalculate and pay the compensation within the 4 months. May I just read?
Within 4 months.
Yes.
This was passed on when?
May I read?
Yes, please.
Start from the para 27. In view of
Operative
above,
person will do. Yes, okay.
yes. In view of above conclusion, this court is of the considered view that compensation as computed in respect to the lands acquired of the petitioners herein would now be required to be redone by the respondent authorities, strictly applying the provisions of said Act of 2023, along with the clarification issued thereon by the Government of India. Accordingly, the respondent authorities are directed to compute the compensation that would now be required to be authorized to the petitioner in lieu of acquisition of their respective lands for the purpose of the construction of the road involved under the Trans-Arunachal Highway project by reckoning the rates as applicable and notified by the respondent authorities and highlighted in the rate petition for the areas wherein the land of the respective petitioner are so situated thereafter to release to the petitioners, and hence the compensation after also making the such computation by including therein solatium and interest as would be applicable in terms of the said provisions of said Act 2023. The exercise now required to be carried out by the state respondent be initiated and concluded within a period of 4 months from the date of receipt of a certified copy, or that's important, my lordship, on the receipt of the uh,
Copy of this order.
4 months from the date of receipt of a certified copy of the order.
Right.
So that is important after the receive a certified copy of the order.
So
now
you
I've
have
just-
submitted this judgment copy.
Yes, we have furnished this judgment copy, and I will just take to the date when this judgment copy was furnished to the authorities. It's in page
724. So-
page is in,
It's after 1 year.
yes. It's annexure 2. Annexure 2, also may see page 187. 187.
Yes.
Forwarding, may subject forwarding of honorable court's order in WPC number 361, because there is a many writ petitions are there. So this writ, all the writ petition was disposed of together. So writ petition, our writ petition is 361 of
Mm.
2017.
Mm.
So your lordship may see the last receipt date is 23rd August 2024. So that is an important date, your lordship.
Okay.
So we have, they have received the certified copy on 23rd August 2024. So now if we calculate the
So it will be
date,
22 December.
no, date of receipt by the,
No, if we calculate, then the 4 month would be.
4 month will, from the date of the receipt of the certified copy, that is
December
23rd, it will start from, expiry for month is 22nd December 2024. Expiry of the 4 month. It's a 22/12/2024. And then date, from the date of the contempt committed is 23rd/12/2024. Then limitation period starts from 23rd/12/2024. Then our limitation ends 22nd/12 of this month, which has not come.
The registry has not recorded any. Okay, we'll issue notice then.
Yes, my lord.
Mm.
So this is within the limitation.
Or Mr. Esmao. Learning counsel for the petitioner. Stop there. This is a contempt petition filed under Article 215 of the Constitution of India. Read with Section 11 and 12 of the Contempt of Court Act 1971. Read with Rule 9 of Contempt of Courts, Guwahati High Court Rules 1977. For deliberate non-compliance of the order dated 18/7/2024 passed by this court in WPC 361/2017. There are other WPC also,
Yes, WPC, yeah, WPC is 361.
361 only.
Yes, up to 2007.
And what is this WPC
Yes, I
274?
will just take to that WPC. It's in page,
No, what is this? You're not connected with WPC 274 and 02 to 2018.
no, mine is connected with 161. Your lordship may see
361.
161 page. 161 page, Runchi Mega. (161 page).
Okay, you're concerned with only one.
Only one,
Okay,
that WPC 361 2017 only.
okay. Stop. Huh? How many respondents are there?
There are
Issue notice.
four respondents. Four respondents. In the page 5 of the petition.
The petitioner shall take steps upon the respondents by a speed post as well as by usual process within a week from today. Staff, let list this matter after 5 weeks. 4 weeks.
4 weeks.
Okay.
Obliged.
Item number 2.
My please lordship. My lord,
Yes.
in this matter, this is second round of litigation. The earlier bail petition was filed. Then it was withdrawn and this, we are challenging in the present criminal petition. The order passed by learned a special judgment.
This is criminal petition.
Yes, ma'am. My lord, can you see the page 31?
My lord, this is criminal petition, but they are praying for bail actually. The
Yes.
nomenclature is criminal petition, but my lord, they are challenging the order passed by the session court wherein 161 provision of the CRPC corresponding to 187 default bail, although the entitle has not been granted. So this is the successive one.
I think I should be allowed to speak first.
No, no, just only criminal petition.
Clarification.
because-
Yes, ma'am.
Okay.
My lord, let me finish, then my brother can then answer whatever he wants to.
Hmm.
Appreciate his assistance, my lord, all the time. Here, my lord, we are specifically challenging the order dated 7/10/2025, my lord, which is at page 31.
Yes.
My lord, the section that was charged against the present accused person was his lordship will say was under section 21B of NDPS Act, my lord. Page 31.
Yes.
So, therefore, my lord, it's below commercial quantity. So the maximum period, my lord, is 60 days for default bail. So default bail was applied, and this order was passed. My lord, why the bail was rejected, man? Now kindly see, my lord, page 32. If lordship second, it is submitted that if the contraband, lordship got it, like second line, it is submitted 32 page 32. That if the contraband substance was scaled without vials, it would come within the intimated quantity and offense under section 21B of NDPS Act is attracted against the accused Jiten Biswas. It is submitted as the IOS failed to submit the charge sheet, the accused Jiten Biswas may be released on bail. I have also heard submission made by learned SPPP. It is submitted that though there's no segregation of contraband substance from the vials, but it is come within the meaning of commercial quantity of contraband substance and offense under section 21C of NDPS is attracted against the accused person. It is further submitted by learned SPP. Accused of Jiten Biswas is habitual drug peddler and he is about 5 cases pending involving possession of supply of drugs. It is submitted accused person may not be released on bail as offense of possession commercial quantity of contraband is attracted against him. Now, this is important. I have carefully perused the case record and seen that initially one Tanya Tatar was apprehended with contraband substance and he disclosed that he purchased the contraband substance from accused Jiten Biswas. Accordingly, police team raided residence of Jiten Biswas and recovered several soap cases of contraband substance measuring 82.47 grams, 270 vials of contraband substance measuring 373.4 grams, including vials and 12 strips or nitrogepam tablets containing 10 tablets on each strip, besides 332 numbers of empty vials. It reveals the accused person was in possession of commercial quantity of contraband and he is a drug peddler. Though present case is registered under section 21B of NDPS Act, however, the offense under section 21C of NDPS is against accused Jiten Biswas. Besides, there are 5 more cases involving possession and supply contraband substance is pending against Jiten Biswas. There is no doubt that he is habitual drug peddler and present case cannot be considered lenient because there is a rider under section 37A of NDPS Act which act while granting bail to accused person found commission of offense involving commercial quantity. Now what happens, the police investigation agency, the production, the quantity is of intermediate quantity. How the learned court could have come to the conclusion that it's commercial quantity?
Okay, now what is the
Now,
status of the case?
now it has been charge sheeted.
Charge sheeted?
Yes.
Subsequently?
Yes.
When?
That charge sheet I have the next month.
You have annexed?
Yes.
When it was charge sheeted?
Hmm?
Let us see the date,
Your Lordship, 37.
37.
Yes, it starts from 36, madam.
Let us see the date when it was charge sheeted before the court.
Here, the first page is there, 6/11/25.
6/11.
Yes,
37,
36, madam.
36.
Yes. Forwarding of this one.
Okay, this
But
bail
it
application
is-
was filed on?
The next page, here is the date of charge sheet numbers, serial number 3, madam. 55/25, date 13/10/2020.
Page,
37,
serial number 3.
3, charge sheet number,
Yes,
yes, 25, date 31/10/2025.
3110.
Yes. And this was forwarded by the SDPO on 6/11/2025.
Okay, so when you file this bail application,
This bail application, Lordship, was 7/10/2025.
710.
Present, my lord.
Yes,
No, 8/12, madam. Madam, but I'm submitting, I entitled to default bail on 7/10/2025. I should have been released.
no. 7/10/2025.
Yes,
What is?
because I have already completed 60 days in the custody.
7/10/25.
Yes,
Okay. Now my question, earlier bail you have withdrawn already.
yes, ma'am.
And then rightly or wrongly, your bail application before bail filed before the special judge was rejected.
Yes.
And this bail application was filed when? This present bail application?
Present application, ma'am.
Yes,
8/12, madam.
8/12.
Yes.
Charge sheet filed on?
It's forwarded on 6/11/2025.
6/11.
Yes.
So this application you have filed only after filing of charge sheet.
Yes.
Okay.
Because what we are submitting is we entitled to, I was entitled to
No,
default
you
bail.
were entitled
Yes,
according to
ma'am.
you, but it was rejected.
Yes. On the premise that the quantity is commercial quantity, madam. How the learned special court could have come to that conclusion, madam, when the investigation agency said that it was under 21B. Contrary, madam, how the sections could be changed during the bail hearing?
Now, since charge sheet has already been filed, whether the FSL report has come?
No, but in the charge sheet also the charges are under section 21B only.
21B only?
Yes,
Charge sheet or
yes,
subsequent?
yes.
Okay. Anyway,
So, madam, in that case, I was entitled to default bail, but that has been wrongly rejected. Therefore, we are challenging that order and bring this honorable court to set aside that, quash that order, madam, and release me on default bail, madam. That's what we are submitting.
some technical difficulties
Yes.
are also there. Yes. So,
My lord, actually, the whatever submission has fallen from me was in favor of my brother,
yes,
senior brother, my lord. Actually, the criminal petition nomenclature that has been just inside, a criminal petition is there because, my lord, they have assailed the 167 application has been rejected. And now the question here is at that point of time, whether they were entitled for default bail or not. If they entitled, and later on, if they challenge it before this court, it will continue if they entitle. I will come with the law, my lord, because your lordship, I have to be fair. I have to be fair so far as your lordship law is concerned.
Taken as a challenge to that order.
Yes, my lord. Now, your
So
lordship,
if it is a challenge, then
Yes.
it will be a continuous.
yes, continuation, my lord. Why, my lord? Because your lordship, the Ravindra, I have your lordship furnished the one judgment of this FX court, my lord.
By this application, they are challenging the order dated
710,
710.
yes, my lord.
They have impugned the 710 order.
Yes, my lord. Now, my lord,
Saying that they were entitled.
yes, my lord. Now, my lord, first we'll see, we'll scan whether it will continue. If suppose, assuming if they entitle, now the filing of this criminal petition will continue the indefeasible right to the accused. That your lordship will understand from that
No,
law,
no,
man.
See, of course, that way you are right, but then rightly or wrongly, it was once rejected on 7/10/2025. Unless he challenged, of course.
Yes, my lord.
His right to release on default bail is gone.
My lord, interestingly, my lord, in the meantime, actually, it should be come from them, but I'll clarifying this. They have preferred an application before this court.
Hmm.
It is not a case where they
That
slept
was
off, my
withdrawn.
lord. It
That
is
was withdrawn.
yes, they have filed a bail application before this honorable court.
Prior to filing of the charge.
Yes, my lord. Invoking 483
Hmm.
of the BNSS, my lord.
Hmm.
But your lordship, this court cannot adjudicate the order which has been impugned 7/10/2025.
Hmm.
So on that ground, they have withdrawn the application, bail application,
Challenge.
and challenge it.
Hmm.
Now, my lord, whether the right accrue at that point of time, which has been able before the learned special court, whether that can be continued, that can be considered as continuing or continuation of the indefeasible right or not. That has been discussed here, my lord. I have furnished the judgment.
Now see, the technical difficulties come here is that after rejection of their bail,
Yes, my lord.
default bail,
Yes, my lord.
and in between the rejection of the default bail and the subsequent filing of this petition challenging the order,
Yes, my lord.
the police has already submitted charge sheet into.
Yes, my lord.
Case on
Yes, my lord.
31/10,
Yes, my lord.
sorry, 6/11.
Yes.
That would not take away my right, my lord. That's what, yes, what we have submitted.
So that need to be satisfied.
Yes.
Yes, my lord. That has to be clarified.
That
Yes.
one.
Now, so because this is the legal aspect and the procedural aspect is there. So, my lord, I will making a fair submission, my lord. So now here in this case, if they have never preferred for any application while availing this indefeasible right, I will come on the later part. I will come out. Now we'll assuming that is 21B where where they are entitled. On that aspect, if entitled, they file before the learned special court by availing their indefeasible right, which has been rejected by the learned special court, my lord. Wrongly or rightly, this is subject matter before this court. If this court find that it has been wrongly rejected, then, my lord, that will continue.
No, what I'm saying.
Even if charge sheet is
is
filed, my lord.
rightly or wrongly.
Yes, my lord.
The trial court has rejected his default bail,
Yes, my lord.
saying, assuming that it is not under 21B, it
Yes.
is under 21C.
See, yes.
So after rejection, subsequently the police has filed charge sheet.
Yes, my
And
lord.
they have come before this court only after filing of subsequent
But
charge sheet only.
yes, my lord, prior to that,
Now, although of course they have challenged
yes,
the earlier order,
prior to that, my lord, they have filed a bail application, which was pending before this court, my lord.
can that be taken account?
Yes, my lord. Why? Because, my lord, they have invoked the wrong provision. 483, they have invoked, my lord, for regular bail. But since with
That is different then.
with an impression that it will be challenged, assailed in the bail application itself. But this court was of the view that if this order
Unless
710
that
is
was
made
challenged.
impugn,
Hmm.
that has to be challenged. My lord, just come to the judgment of the FX court, my lord. There, my lord, this aspect has been clarified. If during the pendency of the appeal, if charge sheet is filed, any application is pending before the appellate court, that will not take away their right, my lord.
Wait.
My lord, this is the judgment rendered in by FX court in M. Ravindran versus Director of Revenue Intelligence, reported in 2021 to SCC 485, my lord may directly come to para 25.
Yes.
Therefore, therefore, in conclusion, once the accused file an application for bail under the provision of section 167(2), he is deemed to have availed of or enforced his right to be released on default bail, occurring after expiry of the stipulated time limit for investigation. Thus, if the accused apply for bail under section 167(2) CRPC, read with section 36A4 NDPS Act, upon expiry of 180 days or the extended period, as case may be, the court must release him on bail forthwith without any unnecessary delay after getting necessary information from the public prosecutor as mentioned supra. Such prompt action will restrict the prosecution from frustrating the legislative mandate to release the accused on bail in case of default by investigation agency. Now, this is 1125.2. The right to be released on default bail continue to remain enforceable if the accused has applied for such bail, notwithstanding pendency of the bail application or subsequent filing of the charge sheet or a report seeking extension of time by the prosecution before the court, or filing of charge sheet during the interim interval when challenge to the rejection to the bail application is pending before the higher court. Madam. Here, my lord, they have preferred an appeal. Rightly, whether that appeal was maintainable or not, that is different aspect, but they continue it, my lord. Now, 25.3. However, where the accused failed to apply for default bail when the right accrues to him, and subsequently a charge sheet, additional complaint, or a report seeking extension of time is prepared before the magistrate, the right to default bail would be extinguished. Here, my lord, if they not availed it, here in this case, they avail it before the special court, my lord. Charge sheet addition so and so seeking the magistrate would be at liberty to take cognizance of the case or grant further time for completion of the investigation, as case may be, though the accused may still be released on bail under other provision of CRPC. Now 25.4. Notwithstanding the order of default bail passed by the court by virtue of explanation 1 of section 167(2), the actual release of the accused from custody in contingent on the direction passed by the competent court granting bail. If the accused failed to furnish bail and or comply with the terms and condition of the bail order within the time stipulated by the court, his continued detention in custody is valid. Now here, my lord, they avail it, my lord. Before availing the right accrued to him, then it will extinguish if subsequently charge sheet is filed. But here in this case, they avail it, but it was denied. Now this court has to see whether the denial order was correctly denied or not. If correctly denied, then their right goes. If they made out a case, if the order is perverse one, then it will again continue, my lord.
Now we have to see
Yes, madam.
the charge sheet was filed well when the subsequent bail application or the application challenging the rejection order is still pending,
Now, my lord,
or the charge sheet was filed, or at the time of filing charge sheet, whether we have to consider whether there
any
was
application
bail
was pending or not.
pending.
Yes, yes, my lord. Now, my lord, interesting.
Now, in the instant case, probably when the charge sheet was filed, no bail application
My lord, for that record has to be called for. Why? Because, my lord, the date which is provided in the charge sheet.
Okay, what will do, will call for the record.
Yes, my lord, because this date is regarding the completion of investigation, not the
Right.
filing of the charge sheet. Filing of the charge sheet we can ascertain from the record and order passed by the Lani Special Court that when the charge sheet has been received.
Had Mr. Pitapur, Land Council for the petitioner. Also had Mr. A.T. and an additional PP for the state staff. Huh? This application under section 528 of the Bharatiya Nagrik Suraksha Sanhita 2023 has been filed by the petitioner. Challenging the order dated 7/10/2025 passed by the Land Special Judge NDPS UPR, whereby the default bail, whereby the bail application under section 480 read with section 187 to BNSS has been rejected on the ground that it is on the ground that the offense under the offense against the accused is under section 21C NDPS Act 1985 and not under 21B of NDPS Act, and therefore the section 21C NDPS being commercial quantity, the statutory period apply would be 180 days. Stop. The petitioner also seeks default bail. Praying for enlargement of the accused on default bail. Stop. Para. Call for the issue notice. Call for the record. Then, Mr. Just a minute. Land additional PP submitted. In the meantime, the case has already been submitted into charge sheet on 6/11/2025. Charge sheet is 6/11. 3/10 or 6/11.
611 is forwarding, forwarding the,
It's 31. Forward. When the court received it. When it was received before the court or by the court. Okay, in the meantime, the case has already been submitted into charges. Okay. Accordingly, call for the trial court record. Scan copy of the trial court record. Start. Please, this matter. When? After 3 weeks? 2 weeks? When?
yes, but because this matter can be taken by your lordship alone, that's the problem. It will be listed before this honorable court,
Before
not before any other page.
Okay. Why?
Because earlier bail was withdrawn
there would be some sympathy.
No, no, because.
Notification
because of
27, my lord.
Notification, my lord.
Okay.
My lord.
Then, we'll get it listed on, 23rd.
Okay, my lord. 23rd.
June.
Yes,
Obliged, my lord.
of like.
Item number 3.
Well, the petitioners are headmasters, vice principal, and district adult education officers now.
Okay.
Now, some of the juniors, before I take my lord, I'll not press too much. I'm pressing for the disposal of something, my lord.
Okay.
So what will happen is, my lord, there is a read petition filed in number 171, 2009. Some of our colleagues, their appointments were irregular. The court held. Then what had happened is, in spite of that, they were given promotions. Now many of them are principals and DDSE. They were principals and the DDSE are analogous post. So now, without going into the legality of their promotions, therefore we have not made them as a party in this read proceedings. Now,
But you are aggrieved by their promotion.
somehow very remotely, what we are saying is,
Ah.
please, oh little king,
Ah.
give us our share of bread,
Ah.
so that we are also promoted against 32 vacant posts, which is lying, my lord.
Okay.
So that is in the form of our representation, my lord. Kindly come to our representation at page 64, that we have been giving reminders to them. So they can recast and they can give promotion to us in accordance with the law, my lord.
Then in that case, if you are so liberal, then you will not be able to claim seniority then thereafter also.
No,
Because
no.
you'll be lying behind them,
No,
even if granted also,
no, my lord.
assuming that the,
No, my lord.
Hmm.
Once what happens, a lease is brought before this court,
Mhm.
and the court, honorable court, gives a direction that you consider their representation
Hmm.
in accordance with law by a speaking
Okay.
order.
Okay.
Then, as a legal right is created.
Okay.
So, beholds the legal right. If the authorities act otherwise, then those question of, my lord, the seniority, then their illegal appointment, all those things subsequently will come. But as of what we feel, because they are also our colleague, now they are settled with a
Okay.
family, why should we disturb them?
Okay.
So since 32 posts are lying vacant, kindly direct the respondent authority to dispose of my representation. That is my instruction. Well, initially, I thought of going for a merit, very sympathetic. My clients are very sympathetic.
Okay. So,
And
So-
Representation.
okay, to dispose of the representation,
Yes,
to dispose of the repetition itself.
itself.
only to consider their representation. and
Dispose the
dispose.
read
Okay.
petition with a direction to the respondent authority to consider the representation, dispose the representation of the petitioner as filed on 11/9/2025 by a reason and speaking order, my lord. Within an outer period of, you can prescribe the date, like 2 months.
2 months, madam.
Fine.
Okay. Heard Mr. Tititara, Land Council for the petitioner. I've also heard
The court.
Mr. Tagu, Land Standing Council for the Education Department, staff, para. This writ petition under Article 226 of the Constitution of India has been filed by the petitioner. How many petitioners? Huh?
Six.
6 in numbers. Stop. Huh? 6 in numbers who are presently working serving as the headmasters, vice principal, and DAEO in the Education Department of Arunachal Pradesh, seeking direction to the respondent authority to correct the seniority list in accordance with the recruitment rules. Semicolon, consider their promotion to the post of DDSE stroke principal against the existence vacancy of 32 vacancies created in the department based on seniority and the eligibility. Semicolon, to regularize and also to regularize the service of petitioner number 6 to the post of DAEO retrospectively from the date these juniors were regularized. Stop. Huh? Mr. Tara, land counsel for the petitioner, at this stage further submits that the petitioners have filed a representation before the, that would be para, huh? Before the respondent authority claiming raising the above grievances stuff. And at this stage, he fairly submits that this writ petition can be disposed of with the direction to the respondent authority to dispose of the representation submitted by the petitioners on when you said 11
11/09/2024, page 64, man.
11/09/2025 and the reminder on 8/12/2025. Stop. Huh? Mr. Itogong, Land Standing Counsel for the Education Department, has no objection to the extent of this court directing the respondent authority to dispose of the representation. So some is representation the above representation submitted by the petitioner before the authority. Stop. Huh? In view of the above, and agreed upon by the parties, this writ petition is disposed of with a direction to the respondent authority, more particularly respondent number 1, to dispose of the writ petition, representation dated 11/9/2025 and reminder dated 8/12/2025 submitted by the petitioner. Strictly in accordance with the recruitment rules, in accordance with the So it will be in accordance with the rules.
Rules, in accordance with rules.
Accordance with law only, man.
No, law is different. Because now it is
Rules and
governed by
laws.
the rules now. 309 and subsequent rules. We are not interpreting the statute.
In accordance with the rules.
Yes.
And we'll say in accordance with the rule only, okay? There is RR also, and then you are
RR.
claiming for against, in,
32 vacancies, and then they will recast the seniority and will give all consequential financial.
And,
benefits.
As per rules only.
and based on the eligibility of the, based on the eligibility of the petitioner in accordance with the their seniority position.
Correct.
Good. Okay. Within the period of 60 days,
Yes, madam.
60 days from the date of receipt of this
Certified.
certified copy of this order.
By a reason done speaking order.
With a region order, okay, bypassing a region and speaking order
Grateful, madam. Great.
Okay. with the above this, with petition stands disposed of. Okay.
Deeply.
Item number 4.
My lord, just I was writing something before I
Mhm.
proceed with this case. A man dismissed without cause is a question mark that civilization forgets to if answered. In the absence of reasons, power speaks only in echoes of removal. Now this poor watchman, my lord, is so pathetic after going through the impugned termination order. My lord, the fact, before I indulge this, my lord, with the annexures, my lord, the fact is this: the Food Corporation of India writes to the Deputy Commissioner of various districts in Arunachal Pradesh that they are in requirement of watchmen and some other people. One. Number two, then the FCI enters with an agreement, my lord, with the State Food and Civil Supplies Department. There, on the basis of that agreement, the Deputy Commissioner, on the request of Food Corporation of India, recruits many watchmen, my lord, and some other people at the paltry amount of, my lord, 4,000 and 8,400 rupees. And the Deputy Commissioner recruited, and in clause 6 of the appointment order, that the services of this employee will be at the disposal of the Food Corporation of India, my lord. Then, in the meantime, they comes out with an OM saying that now we are going to deploy the GDR. GDR DGR sponsored securities in place of that security agencies. Be that as it may, my lord. Now the question comes: can you recruit a person without giving a show cause notice? Can you terminate them? The answer is no, my lord. Apex Court very recently in Gola versus Jago case. I'll place that Jago case. My lord, the law is well settled. The fact of that Apex Court judgment is applicable in my case. Now, that is how, my lord, we have, with the petitioners are before this honorable court. Now, my lord, kindly see that the question of law, which my lord will frame the determination of the lease, would be: can a employee, whether a contractual or a regular employee, even temporary employee, can be terminated without serving any show cause notice, and without affording an opportunity of being heard. The answer is no, my lord. The Constitution, Article 311, Clause 2, clearly protects. And that is further, my lord, proclaimed and established by the apex court judgment. No, you cannot do this. Here, my lord, although they have issued the impugned termination order in the month of September, but that was lately communicated to us. Then we have filed a representation accordingly, my lord, on 3/12/2025. So that is our case. Now, my lord, kindly come to page 23 for the facts. My lord, the type copy, my lord, will find that page 24.
Yeah.
Here, the Food Corporation of India writes, the regional office, to the Deputy Commissioner, Upper Subansiri District, so and so. Requirement of watch and ward staff at FSD Daporizio. Sir, we do intimate your esteemed office that we require one numbers of contractual watchmen for deployment at FSD Daporizio. Please do the needful to issue appointment from your end to eligible candidate as per the agreement made between the Food Corporation of India and state government. A copy is enclosed. Also, para 2, also please ensure that candidate may submit his permanent and present address, documents pertaining to educational qualifications, character certificate and caste certificate, and specimen signature without fail. In addition to above, it may be clearly mentioned in the appointment order that he will have no right to claim for regularization, stroke absorption of his service in future, and FCI may terminate his service at any time if his service is not felt necessary. His monthly fixed salary will be 4,000. Appointment will be on the terms and conditions as per MOU with the state government, a draft copy. Now, my lord, kindly come to next page. This is the appointment order.
Contract basis.
Contract basis. My lord, we are not even claiming for the regularization. Nothing. We are not saying anything. Now, my lord, kindly come to one paragraph of the appointment order, my lord. Para 6. The Deputy Commissioner, on their request, have recruited this petitioners. Clause 6 says the service of the appointee shall be under the disposal of the port in charge for the FCI duties. So therefore, my lord, the Deputy Commissioner is nothing to do with. Deputy Commissioner per se, my lord, has acted as an recruiting agency on the request of Food Corporation India. Now, my lord, kindly come to next page. This is the petitioner number 2, my lord. Page 30, my lord, the type copy.
All were appointed on a similar.
No, but this
Condition.
man is appointed watchman, my lord, but his salary is bit higher, the monthly, in 2016, my lord. This is appointed in 2016, my lord. So 8,400 revised because the petitioner number 1 also got. But similarly, my lord will find the same clause in the 6th. Now, this is petition number 3, yeah? 2. Now, my lord, page 32 also the same, my lord will find page 30 to 33 is the type copy, my lord.
Yes.
The 6, serial number 6, the services of the appointee shall be under the disposal of the port in charge for FCI stroke FSD and DRG. Now, my lord, kindly see the type and lecture 3-4, my lord, the type copy, my lord.
Nice.
Now the problem started from here. To the Deputy Commissioner, Capital Complex, so and so all, my lord. Handing over of services of security guards appointed by Deputy Commissioner for FCI depots. FCI RO even number. Now, my lord, I am bound to read this letter, my lord. One paragraph, my lord, but kindly come to page 37, my lord. Apropos to the above subject, it is to inform that the Food Corporation of India Regional Office at Itanagar, Arunachal Pradesh, had started independent functioning from the year 2008. Prior to this, PDS operations of the state were handled by FCI Regional Office Guwahati, Assam, and various district offices located therein. At the initial stages of establishing offices, the staff and security guards for running day-to-day operations of FCI. For a smooth functioning of the operations, AP state government was requested to depute staff of state government and deploy security personnel on temporary basis. However, with the passage of time, the operation of the state have stabilized, and all the deputed state government staffs have returned to the parent department from FCI. As on date, only security guards provided through various DC's officers are still present with. Now, here one. As your good self may appreciate, FCI Arunachal Pradesh is governed by the Government of India Office Memorandum dated 11/02/2005 and various standing orders of FCI headquarters. As per the memorandum dated 11/02/2025, all central government public security undertakings, enterprises are required to take security cover from security agencies sponsored by the Director General Resettlement and attached office of ex-servicemen Welfare Department, Ministry of Defense. Now, after this letter, my lord, this impugn order was next. Thereafter, my lord, the interesting page 40, my lord, the type copy of the Annexure 5 series. This is the Deputy Commissioner, my lord, writes. The Director Food and Civil Supplies writes back to the Food Corporation of India, handing over, my lord, 4/3/2025 letter. If my lord has, I read it. The General Manager, Reason, Food Corporation of India, Itanagar, handing over of services of security guard recommended by Deputy Commissioners for FCI Depart's office regarding. While memo number 7, sir, while inviting a reference to the subject cited above, I would like to clarify that the Deputy Commissioners had merely recommended by verifying the characters and antecedents of candidates, thereby ensuring right people were appointed for food security guards in the FCI Depart offices. The Department of Food and Civil Supplies and the Deputy Commissioners, Government of Arunachal Pradesh, had no role in appointment of security guards. Therefore, the question of absorption taking over the services of the security guards. Well, just I'm posing with this line. The FCI turning out to be a wolves, Miller. They're just, you are asking the state government to recruit on your behalf and you are giving the payment. And now, after deploying that DGR security guards, they are saying that, no, it is duty of the state government, trying to create a conflict. This is not permissible. Therefore, the question of absorption, taking over the services of the security guards appointed by the FCI by the state government is not tenable and cannot be entertained. Instead, considering their dedicated and sincere service rendered by these security guards for more than a decade in the FCI since inception in Arunachal Pradesh, it is requested to consider continuation, absorption of their services on humanitarian grounds, as almost all of them had crossed the age bar for recruitment in other agencies, department while serving in FCI. Their continued engagement in FCI will help to resolve local issues, if any, avoid in any repercussions ensuing out of their retrenchment at this juncture. Now, my lord, after writing this impugn order sought to have it, and then 42, my lord, also. The Deputy Commissioner has also written, all the Deputy Commissioners, 11/8/2025, my lord, we'll find at page 42. This is nothing but the reiterations of the letter of the Director of Food and Civil Supply will supersede the letter by the Deputy Commissioner in case of the administrative hierarchy. Now, my lord, after these two communications, directly they have issued the impugned discontinuation order, which my lord will find at page 45. This is how we have been discontinued. 23/9 forenoon. Further, you are directed to vacate the FCI quota without further. The subsequent, my lord, the people are, my lord, all the names are given below.
Hmm.
Only it is, my lord,
was
this
in
memorandum was already in.
September.
Mr. Singh, please sit down. I have to place the judgment.
Okay.
So, my lord, see this memorandum, there is nothing is also there in detail. So, as what is a page 48, my lord, then we have submitted our representation on 3/12/2025, which my lord will find at page 46 and 47. Our representations. Then, my lord, page 49, my lord, the office memorandum which they have referred to. 11 February 2005.
Hmm.
The undersigned is directed to refer to this department OMs. I think Mr. Singh will bring it here. OMs of even number dated 12/1/2/1999, 27/1/2003, and correspondence dated 17/7/2003 on the subject mentioned above, and to say that after reviewing the situation, it has been decided that the Director General, Resettlement DGR, will be the nodal authority to sponsor security agencies, including page number the 49. It is there. Okay. Agencies including state ex-servicemen security corporations to all public undertakings. Now, my lord, even kindly see the objective of this OM also. They have never thought about, per se, never had a human approach. What about these poor people who have been guarding you? Once the guards are terminated, the guardians are guarding the guards now. All there. So, my lord, now I'm making categorical, I have made a categorical statement, my lord, para 13 of my read petition, my lord, saying that this is arbitrary, unreasonable, and violation of the natural justice. Without issuing any, my lord, page 14, my lord, will see the continuation, which page 13 and 14. I have made a categorical statement, my lord, which I need not to read even, my lord. It is rightly drafted, Lord. Next, I state, the petitioner further submits that they have rendered continuous and diligent service as contractual watchmen at FCI, FSD, the operator for several years. By virtue of their long service, the petitioner had a legitimate expectation of continuation in service and to be governed by the settled principle of natural justice and fair administrative procedures. The impugned ex parte discontinuation order dated 23/9/2025 is arbitrary, illegal, and unreasonable, having been passed without issuing any show cause notice, without inquiry, my lord. That is what I was referring to, my lord, Article 311.
Yes.
Sir, even like kindly see, my lord, we have our service length is described at page paragraph 14, my lord. The petitioner number 1 was appointed in 2011. Completed 14 years. Then petitioner number 2 was appointed in 2016 and has completed 9
Okay,
years.
yes, you are appearing for?
Appearing for Food Corporation.
You have received the copy?
Yes, ma'am.
Okay.
Writ petition copy. I have the.
Now, my lord,
Okay,
I'm placing this authority because I'm praying for the stay.
stay. The order was passed way back in the.
No, my lord,
Already been passed, my lord.
order has been passed.
Hmm.
On receipt, we have filed the representation on 3rd December 2025, my lord. Thank you, lord. These, my lord, cannot be permitted, my lord. How they are going to stop, my lord? This is a case relating to Central Water Commission, my lord. The fact, my lord, will find on a similar pedestal, my lord. I read out, my lord. Para 4. Para.
Yes.
The appellants before this court being applicant number 1, 2, 3 and 5 before the tribunal were originally engaged by the Central Water Commission on part-time ad hoc terms. Applicant number 1 was appointed as Saifari. So I'll not read that. This now kindly come to para 14 straight. This is the fact. The fact of this case is fit into the scheme of this lease, my lord. Para 14. The abrupt termination of the appellant services following dismissal of their original application before the tribunal was arbitrary and devoid of any justification. The termination letters issued without prior notice or explanation violated fundamental principle of natural justice. It is a settled principle of law that even contractual employees are entitled to fair hearing before any adverse action is taken against them, particularly when their service records are unblemished. In this case, the appellants were given no opportunity to be heard, nor were they provided any reason for their dismissal, which followed nearly 2 decades of dedicated service. It's very painful to see. Kindly interfere with this, because in any case, they are going to invoke the doctrine of no pay, no work. Till then, this suspension order, termination orders will state.
Yes, Mr. Singh.
May it please your lordship.
Yeah.
My lord, admittedly, the petitioner were appointed by the deputy commissioner, my lord. And the later on this by order dated 23/9/2025, their services has been discontinued. And my my friend has already read all the annexes. I did not read again. My lord, we have also issued one 9/6/2025 letter to the Director Food Civil Supply stating that we are implementing the DGR services with effect from 9/6/2025. And from 10/6/2025, we have engaged DGR sponsor, my lord.
Since when?
From 10/6, my lord.
10/6.
10/6.
Now they are performing duty.
Yes, my lord.
Oh, great. You can, my friend BK Singh can come in the form of affidavit.
Obviously, we will file. Today is motion day, my lord. So, my lord, in the 9/6/2025 letter, we have written to the Director of Food and Civil Supplies, stating that we are appointing the DGS security guards as per the office memorandum of various office memorandum of FCI, my lord.
Correct.
And my lord, the next letter, 13/6/2025, my lord, item number 10, my lord, serial number 10, Food Storage Depot, Daparijo. The petitions are from Daparijo, my lord. The date of deployment of DGR guards is 10/6/2025. My lord, if this order is illegal, your lordship will, of course, will interfere with it. And as my learned friend has given the Jagos citations, my lord, back wages will be given, my lord. And very interestingly, my lord, Deputy Commissioner has not been made party. For proper adjudication, Deputy Commissioner and Food Supplies, Civil Supplies ought to have been made party in this writ petition, my lord, because admittedly they have appointed by the Deputy Commissioner, my lord. And we have categorically stated that kindly deport the staff of the state government. So I think they were earlier the staff of the state government. We have requested the Deputy Commissioner office to kindly deploy the persons to.
Okay.
So my lord, at
Please
this
do
stage
not-
only notice may be issued, and we will try to make an effort for early disposal. my lord.
Petitioner.
No, the salary is not paid by the deputy commissioner, only
Even
recruiting
when
agency.
Mhm.
So the deputy commissioner is not a necessary party. Service is also under them, my lord. So my grievances would be against them only in the FCI. That's fine.
this the present petition under Article 226 of the Constitution of India has been filed by the petitioner, being agreed by the abrupt termination of his
My lord,
of
the
their-
word is
of their-
discontinuation, not termination, my lord.
Hmm?
The word is discontinuation.
It stands
not-
corrected.
Okay.
Not
It is
terminated.
discontinuation, not
Or
termination.
by the discontinuation of their services, their contract services for more than 10 years without and illegal, without giving without issuing any so-called notice and providing opportunity of being heard. It is content that the where somewhere you said that you were verbally informed. Hmm.
They have verbally informed, but the
Hmm.
order copy was not served
Okay,
till 3rd of
that only
December.
the respondent, the authority has only verbally informed them in the month of June. However, no formal notice. No so-called notice were issued to them, nor given an opportunity, and hence the discontinuation. Order dated 23/9/2025 is arbitrary, illegal, and illegal. Stop. Issue notice. Since Mr. Singh, Nana Council appeared on the could appear and accepted notice on behalf of the respondent number.
All the respondent.
All the respondents, no formal notice need be issued. However, extra requisite copy be furnished to him. How the petitioner shall furnish an extra requisite copy to Mr. Singh during the course of the day. Stop. Para. List this matter after.
In the 3rd week of February, meanwhile, we will file our affidavit in
Okay.
opposition.
In the
We will
meanwhile,
expedite the
Mr. Singh shall file his affidavit in opposition if any. Stop. Para. Considering the nature of grievances raised by the petitioner, it is directed to the respondent authority. Sorry, the land council for the petitioner submits that the petitioner has submitted the representations for revocation of the discontinuation order before the respondent number
3.
3. Stop. That will be in his submission. Okay, in the last, considering the grievances raised, the respondent, more particularly the respondent authority, who is directed to dispose of the representation submitted by the petitioner on
My lord, may I request?
3/12/2025 by by passing a region order.
My lord,
Hmm.
may I just,
Yes.
my lord, issue notice this representation may not be disposed of because otherwise, before filing the affidavit in opposition,
Hmm.
they will make the repetition infructuous. So therefore, my lord, kindly suspend this termination order.
No, my lord.
It was
Then they will
suspended
come
long
with
back and they
contempt
have
matter,
already
my lord.
already engaged in.
Yes,
What is
my
this name called?
Yes, on
Hmm.
from 10/9, my lord.
If
If it
you
is succeeded,
succeed,
then they will
you
come up
will
for,
get the back
they will
wages.
come up with contempt petition, my lord.
Hmm.
If the writ petition will be allowed later stage, obviously they will get all the back wages, my
Back
lord, as per the
wages.
Jagos case cited by my learned friend, my lord. So at this stage, only
Okay,
notice will
then-
be issued.
okay.
We will expedite the matter,
Only
my lord.
That notice, release this matter after 4 weeks.
No,
My lord, in the third week of February, meanwhile, we will file our affidavit also.
Okay.
no, let us fix the
Pray
date.
for,
Yes,
this
yes.
matter.
26.
Okay.
17th
Requested by both the Lana Council for the
17th
parties. List this matter on.
My learned friend, Mr. Singh will file his affidavit.
by 13, by 13.
By 20, will serve 43 on 16, Lord.
Okay,
Then
Mr.
17, the case would be listed.
okay, on 17, huh? Mr. Singh. Okay. Mr. Singh, in the meantime, Mr. Singh shall he file the affidavit on behalf of the respondent by by
13th of February.
13 of February. So,
And sir-
so on the
sir-
same day you can
sir,
say,
copy
and will
to the-
serve the copy to me on the
to the
same.
petitioner on the same day. Okay.
My lord,
My lord, extra copies may be, extra copies.
Extra copy.
my lord, kindly,
You furnish the extra
Yes,
copy request.
yes, kindly make a small observation. My lord.
Oh, yes.
The impugned discontinuation order
Hmm.
shall be the subject to outcome
Yeah,
of this.
obviously,
Okay.
obviously.
They kindly make mark.
Yeah, that the discontinuation order dated so and so shall be subject to the outcome of this petition. Okay.
My lord, same thing, next case is of Changla.
Similar case.
Similar case,
Okay,
same case.
similar
Only
direction,
district is different and petitioner name.
Okay, petitioner names
Yes,
and then would be different. Okay, similar order.
I'm
Okay.
grateful.
Obliged, my lord.
Item number 10 and 11.
May it please, Lord.
Yes.
My lord, item number 11 may be taken up. 10 is an offshoot of item number 11.
Hmm.
Alright. My lord, after the filing of this case, my lord, there has been some developments. I'm given to understand, my lord, that the government is willing to
Hmm.
look into our grievances. So if your lordship can remand it back, subject to what my learned friend says, that is the understanding I have been given. Earlier also, my lord, this honorable court, what has happened, I will just summarize.
Affidavit in opposition has filed.
Yes,
My lord,
everything
you're
has been filed. These petitioners, my lord, they were appointed in 2000. Not yet.
my lord, here, affidavit we have not signed.
As per record, not yet filed.
But
Oh, I
as
thought-
per their submission, my lord, this can be disposed of, my lord.
Mhm.
Only their grievances is this, they are praying for remanding back to the matter to the authority, madam. Since similarly situated case, the government have taken up the matter in their administrative level, madam. Since because of pendency of this matter, may perhaps their case could not be taken up, madam.
Okay.
In similar line, madam, earlier also the order,
The
madam.
writ
I
petition
have-
was disposed
I
of
have furnished.
Yes.
in the similar.
A similar way on.
Similar order.
Yes.
Let the authority consider whether they can be regularized or their reinstate can be done or not.
Okay. Both this writ petition.
No, the other one, my lord, will be subject to what will be the decision of the government, my lord. This may be kept pending, item number 10,
Okay.
Only 11, madam.
only 11.
Start, Mr. Deepansh, Nane Council for the petition. Deputy Director of School Education.
Yes.
Also for providing-
Uh,
This is also same department? The,
Yes,
okay. The contingent peon.
yes, if I will just summarize, it will be easier. for
Right, right,
Lordship.
right.
These petitioners, my lord, they were appointed in 2009, most of them are
Hmm.
to petitioner number 5
Mhm,
as contingent, my lord, staff.
mhm.
Petitioner number 6 was appointed in 2010 and petitioner number 7 in 2012.
2010.
Yes.
Where do we find that?
There your lordships will find from page 30 to 44 of the writ petition,
32?
30 to 44. All of them, the appointment orders are there.
Order need to be recorded here. In,
Maybe I'm just
so
summarizing.
the date of appointment
Date of appointment is,
need to be recorded
my lord may say that they were appointed as contingent employees in the year 2009
in the year
and
2012.
12, yes.
Ah,
Then, my lord, I will just summarize, my lord. If your lordship may kindly page 26 for a moment.
mhm,
This is the recruitment rule of MTS, multitasking staff.
hmm.
At page 26 is starts. Your lordship may kindly have page 28.
Just a minute. 26 is start, page 28.
Yes.
What is this?
Then the method of recruitment at column 10.
Hmm, page 28.
Page
28.
28 is that column,
Column 10.
column 10.
Method of recruitment. Has my lord got it?
Okay.
My lord may, on the right hand side of provisional rules, B.
B, right.
50% of vacancies shall be filled up from among the existing unskilled contingent staff who have completed 15 years of service. So the
15
rule
years.
itself provides for, my lord, appointment of the contingent staff, 50% of them. Now there's a.
Who pass educational qualification of class
Yes,
10?
yes.
Okay. So you are eligible otherwise.
No, at that point I was not eligible. Most of them had completed 14 years.
Okay, now?
So what happened?
Hmm.
Thereafter, my lord, by orders dated 22/8/2019 and 8/10/2020, the petitioners were regularized.
Now this is criteria for, this, column 10 is a criteria for appointment.
Yes.
Okay, they are not eligible.
At that point, not eligible, yes. On the 5 of the petitioners had completed 14 years. So if they had waited one more year, my lord, they would have been qualified. What the
How many
government did-
petitioners you said?
There are 7 petitioners.
7.
Yeah.
None of them have,
Yeah.
none of them have qualified.
At that point of time, yes.
At that point of time means
Yes.
when?
It was way back in 2019 and 2020.
When the petition was filed.
Yes.
No.
Now
No, this
all
was
of them are
23.
qualified.
Hmm?
Now all of them are qualified.
Okay, now qualified.
So what happened, my lord? By 2 orders dated 22/8/2019, 22/8/2019,
Page,
page number is 48 to 63. They were regularized,
who?
the petitioners,
48 to?
66, 63. These are the regulation orders. Yes, my lord, got it. There are similar orders, all of them.
Yes, 48.
Yes. Sri Sasensa is hereby regularized in the post of peon MTS.
Mhm.
So similar orders up to page 63 of all the petitioners. I'm not troubling your lordships with them.
Okay.
Then thereafter, my lord, in 2022, at page 64, so post notice was issued
64.
saying that we have been appointed illegally without observing laid down norms. Everybody received it, my lord. Lordship will kindly have page 90. We replied to that, I will not bothering your lordship with that. Since we are only praying for remanding the matter back. Page 90, my lord.
Just a minute. Page 90.
9, yes,
90 is,
yes. So regularization is to cancel.
okay, after so course.
Yes,
You have filed reply also?
yes, I filed reply also.
Reply is,
Reply is from page number 75 onwards. Page 90 is the order by the commissioner. And subsequently, at page 95 is the further order by the DDSC.
page 90 is,
The order by the commissioner, education.
what is this order for?
The
Commissioner?
regulation was cancelled.
Oh, cancel,
Yeah.
cancellation, okay.
This is under challenge.
Okay,
95 is the order by the deputy director. This order is passed in consonance with the order at page 90.
95 is,
The order passed by the DDSC.
okay, so
Following the
this
order,
commissioner directed to
Yes.
DDSC to
Yes.
pass necessary order.
Yes.
Okay,
So,
Hmm.
so my lord, these orders were actually passed by the well, at that point of time, there were widespread allegations of illegal appointments, my lord, by one joint director at that point of time. No?
Hmm.
It was in that context, my lord, so many were, my lord, appointments were cancelled. But this is a bit different, my lord. And
Okay.
the department also, in their own wisdom, they subsequently, my lord, constituted a committee to look into matters which were not illegal. And they have reinstated 4 persons also. So it is in that context, my lord, I'm given to understand they are willing to have a relook at our matter also. So my lord may remand it back, my lord, since my learned friend is also conceding to that fact. As per law, my lord, maybe they can take into consideration the service we have put in together and maybe they may do something.
since the
in
state
terms-
has not filed affidavit,
My lord.
so, but otherwise you,
Remanding, my lord, we have no objection because ultimately it will be left to the authority, my lord. Authority will consider, my lord. Verifying their records, service records and all. And earlier occasion also similar situation, the government have taken up and they're
remanding with the direction to,
Consider the cases of the petitioner, grievance the petitioners.
okay.
Since
If
now,
they-
in terms of the rules, we are qualified now.
and if they're eligible and genuine their case, they can be reinstated, their case can be considered.
Here the respondent has not filed any affidavit. We'll record your verbal submission,
My lord,
no objection.
my lord,
To
regarding
remanding,
the remanding, we have no objection.
Okay. Okay, we'll dispose of that.
My lord, my lord.
Hard, Mr. Write the name of the parties, huh? Mr. Tagum, Standing Council for Education, Education Department is respondent. State is also the respondent here.
My lord, only 4 is representative of state.
Okay, and Miss Sangita for the performer respondent number 4.
So performance, respondent number 4.
Respondent number 4,
Deputy Commissioner.
not performer. It's not performer, it's a respondent number 4 only.
Yes, ma'am.
Okay, then you have 1, 2, 3, and 5.
3 and 5, yes.
Okay, then Sangeeta 4. Okay, we'll dispose of.
Man,
Okay.
man.
Problem.
And item number,
In item
10 may be kept pending, my lord.
10,
Maybe list,
on the prayer of both the Lanai Council for the parties.
Nine
List this
so-
matter after 4 weeks.
yes, ma'am.
Yes,
Okay,
item number 9.
and then their present may be recorded, huh? Mr.
9, oh, sorry,
No.
10, 10.
Jane Haji Pangi Lanai Council for the petitioner and Mr. E. Tagum, standing counsel for the Education Department, Ms. Sangeeta for respondent number 4, huh? On the prayer of the parties. Let this matter be listed after 4 weeks. Okay.
Man, problem.
This.
Item number 12,
Just a minute. Huh? Mhm. Okay. Yes.
Lots of your, before my learned friend starts, I still want some time to file my affidavit because I have been asking time, I understand, but last occasion also I told my friend that because of the ongoing panchayat election, the officers, they are not allowed to leave the station till the declaration of the results, so they could
Mhm.
not come for swearing.
Okay. So, Ms. Reba Lanet, my regional senior government advocate. Affidavit otherwise is ready. Otherwise is ready.
Otherwise, it's ready.
Okay, some is that affidavit in opposition on behalf of the respondent is otherwise is ready. However, due to the panchayat election, the officer could not come for signing affidavit. Therefore, pray for some more time. Prayer allowed. Mr.
Lordship, maybe on 23 of this month.
Council for the petition is present. Staff, please pray for Kama list this matter after 2 weeks. After 2 weeks. Okay. When?
I want that, but
Lordship, now, as per this, Lordship, already this warning has been given very one order that 21/8/2025. This actually order is
Okay.
like this. In event of the failure to file affidavit on
Okay,
the
next
next
week.
day,
Okay, next week. Okay.
Lordship.
next
You get it signed within this week.
2 days,
After a week, get it listed after a week.
Lordship, 24th is last day of the.
24th. Not before,
When?
not before vacation.
Lordship,
I want-
Immediately after vacation. This is
I
not
want
immediately
that,
after,
but my
after
friend-
the ensuing winter vacation. Okay.
5 January, Lordship. Then.
Why fixed date? They have not yet filed. Immediately after the vacation. Okay, winter vacation. Okay.
Someone will be
Hmm.
here. I am not.
Mr. Kato is also representing for union of respondent number. Okay, Mr. Kato also, huh? His present may also be recorded. Okay.
Obliged.
item number 13,
Yes, Mr. Mo.
May I apply it also?
Hmm.
My lord, this matter related to uh, the petitioner was suspended because of he was alleged in some cases.
Hmm.
My lord, the fact is in paragraph 4. What happened was that he was suspended, but then the suspension was not reviewed. Whereas as per the CC and CCS rules says that if suspension is reviewed.
Not
within-
yet reviewed.
Not yet reviewed, but then she's still suspended. Now, as per Mr. Tagum will not deny, they have filed affidavit admitting that his suspension has not been reviewed within 90 days. So as per this CCA rules, if the suspension is not reviewed within 90 days, then the suspension become invalid. So I've just read the rules, this section 10 subclause 6 talks about.
Respondent file affidavit.
Yes.
My lord, we have filed, my lord, as per the direction of this honorable court, my lord, we have filed the instruction on record. We have brought in instruction on record, my lord.
Okay, what is your instruction?
But as per instruction, my lord, the review has not been done within time frame, my lord.
Okay.
That is, we admitted that part. my lord.
Okay,
And so
Then-
far, their allegation that the subsistence allowance has not been paid, but that is not true. The subsistence allowance is being paid, but the fact of reviewing, my lord, that has not been done, my lord. That has not been done. That's, we concede to that extent.
So on that ground, my lord, your lordship
so
may.
where is your instruction?
My lord, we have brought on affidavit, my lord. At an affidavit, my lord, page 54, my lord. The particular, my lord, in the affidavit also page 52, my lord. Para 2, my lord.
Hmm.
The answering respond back to state that review of suspension order that has shown has not been reviewed or is on that. However, the subsistence allowance is being paid to the petitioner as per CSS Rule 1965. Department proceeding against the present petitioner is going on, and as that no final decision has been taken by the disciplinary authority in this regard. But in the supporting instruction is page 54, madam. And next.
Suspension order was on 10 or 28, 2024. My lord, I will pray that your lordship may dispose of the matter, citing the suspension order and may direct to reinstate. The ground of suspension, my lord, may see the paragraph 4. Married paragraph 4.
Just a minute. Paragraph 4 of the petition.
Yes. The petition was suspended from the service.
He is a DDSC.
Yes.
No, no,
The commissioner. Oh, he's a block
Education
education officer.
block education officer. BEO.
BEO.
He works under DDC in the district.
Okay, why he was, the
Yes,
ground?
is the paragraph 4.
Hmm.
The petition was suspended from service by the Commission on Education by order such and such dated 28/2024 in connection with SIC case number 04/2023 under section 1 such and such, read with one alleging that petition was involved in the illegal appointment in the education department during his tenure as a BEO in Anjar district. Further, it was also alleged that petitioner in his capacity as a BEO had arranged illegal appointment of petitioner's nephew such and such with the help of such and such through the such and such person then DDC Anjar district. That petition had to have involvement in illegal appointment of PRTs, MTS during the petitioner's tenure as a BEO under such and such DDC Anjar.
Why it was not reviewed?
My lord, that I don't know.
So the authority is cooperating.
My lord, that is, I also fail to understand, maybe because, my lord, in the department, my lord, the timely, my lord, there should have been a standing committee
Yes.
for review. Now,
In all the department act.
in all the department, my lord, unfortunately, in this case, my lord, in the education department, my lord.
So everyone is involved.
No, it is not a case, my lord.
There is allegation.
But,
Unless they are involved, they are interested,
my lord,
why would they neglect?
my lord, that part, I have not instructed that. part, my
But this
lord.
is only
Maybe because, my lord, the file, it should have been timely and routinely managed, it has to be put up to the authority.
No,
And if-
that means the person who puts up the file is also involved.
My lord, that I cannot say this, madam, but as per instruction, madam, official instruction, they have admitted that the review part they have not done, madam. Now, only technical issue, on technical issue, they have,
It's probably only in Arunachal Pradesh. Such
Well,
review is
all-
not being done.
right, my lord.
Hmm. And
My lord,
that indicates something more than
my lord,
what it appears to be.
It appears that, my lord, the some of department, including education department, they are not aware of this timely and routine
No,
manner.
they are aware of.
My lord, last time also, I had a meeting. with the
It
authority.
cannot be because they, every day they used to go through.
Yes, madam.
Read these rules.
After this only,
They are
after,
dealing with the rules only.
after having come across this old fact, my lord, I had a meeting with the authority, my lord.
Hmm.
There only during the course of the meeting, man, I come to know that even prior to this, madam, they had not even standing committee for reviewing, madam. Then I advised them and the authority now, I believe that they have now constituted, madam.
Hmm.
This has been done, this has been this present case, madam, along with other case, that has been done.
Now,
Before that,
now what they are,
my lord,
the department is doing it is only the court
yes, my lord,
because
yes,
it's very difficult to pass order where
Yes.
the person is involved in SIC case.
yes, yes, my lord. In
And
this,
they will blame the court only.
my lord,
Court is not responsible for that.
right, my lord. So that's why, my lord, I had also.
And
interacted with the
they
authority,
want they want some order from the court.
my lord. That
They will
is-
deliberately, they will make mistake and they will get an order and
My lord.
say, blame the court. It is only court.
My lord, in earlier occasion also in a similar situated, my lord, in such circumstances, my lord, the honorable court interfered with their suspension order. But there was a liberty of obviously liberty, my lord, after only interference, my lord, they again have to issue the fresh order, my lord. Because there's a default on part of the department also, we cannot, my lord,
Okay.
that part, my lord.
Hard, Mr.
Well, there is a series of coordinated bench judgments which
See,
say that if
yes.
suspension is not done within 90 days.
Obviously, my lord.
See,
Yeah.
that is law, that is rules.
Yes.
But then here is a case where the person is involved. It's
No,
a very
Madam,
serious
i-
allegation.
Madam,
Yes,
even,
madam.
even
In the
if,
serious allegation, this lapse, is it possible unless it is deliberate? It's not possible.
oh,
at all.
that is depend on department,
That-
madam.
that
That
is
is,
why-
That's why I'm saying.
that depend on
That
department.
is well in earlier occasion, madam, well,
just
even
place-
interfering also, madam, liberty has been granted, but obviously, madam, authority, they have to do, madam.
I'll just place the.
They have to,
coordinated
Yes,
bench
yes.
judgment.
for this only, for further proceeding, they have to again issue a fresh.
And then
suspension
this,
order, madam.
you see, the department deliberately doing and causing trouble. Or the land council also to face awkward situation before the
Yes,
court.
yes, that's true.
Hmm.
I'll just read relevant paragraph 12 to 15. Your 12 to 15. This is up to 2024 SSC online Guwahati.
Yes.
Just read the relevant paragraph. This court is of the considered opinion that the authorities are not without any jurisdiction or power to extend an order of suspension in case there is any delay in issuing a formal charge sheet, so first notice within period of 3 months. And only the requirement is to have periodic review within the
It's only
same period
periodic
of
review.
3 months and pass appropriate order within that period. 13, paragraph 13. Lapses on the part of the authorities cannot be a ground for giving effect to an order of extension, which is admittedly made beyond the
Naturally,
period of 90 days. Paragraph 14. As regards the submission made in behalf of the petitioner that in absence of a charge sheet which the period of 90 days, even a written order of extension of suspension is not permissible, is however not accepted as the same is not tenable in law. 15, be that as it may, in view of the aforesaid discussion, the order of suspension of petitioner that such and such is held to have spent its force on expiry of 3 months as no order review extension was passed prior to that. Prior to that, the subsequent order of extension, this was the case of extension order, the subsequent order of extension would not cure the defect which had already been
Yes,
done.
after expiry of 90 days.
Yes,
90 days.
yes. 16.
For
The
one-
order of suspension is accordingly held to have spent its force, and accordingly a direction is issued to reinstate the petitioners in the service, however taking into account that serious nature of the charges and also the involvement and the arrest of the petitioner in a police case, the respondent authority are at liberty to post the petitioner in any non-sensitive post. So in our case, the allegation is there, but then he was not arrested. He was never arrested.
He was not arrested.
No, he was not arrested. And no charge sheet had.
But then the allegation is that he
The
is also
allegation is
involved,
there. Allegation, no doubt. Allegation is there.
not arrested.
Not arrested.
Then the police is also there.
There's a police officer.
No, I can't say that one. So on the,
So where we are now then?
so I'll pray that the suspension, that order may be satisfied and quashed, and your lordship may direct to reinstate the petitioner. my lord.
Even if, my
It will
lord,
be non-substantive post
yes,
Yes,
because the allegation was serious.
yes.
even if, my lord,
But even then also BOE has no authority, has no authority for the to appoint
But
any
what happened
person.
to the criminal case, by the way, here in this case?
Criminal case so far, I am informed that there is no case again. There is a case, another case, but there is no
What is
such
the
case
status-
against him.
Status of the case?
There is no any case filed against him as of now.
Otherwise, charge sheet filed.
Not yet, I think. Even the CCS rules section 10 sub clause 7 also says that if not extended within 90 days, then it become invalid.
my lord,
That's
even
the law is
though,
very clear.
on the ground technical issue, on the legal issue that has been on the ground of non-review of the
Non-review.
on 90 days, my lord, that suspension order may not be valid, my lord. But so far, the proceeding of departmental proceeding, it will continue,
They
my
will
lord.
continue.
If it is
That will
required, my lord, if need be, authority may place them again fresh suspension order if
That depends
time
on
so.
No, that should, I think, my lord, the law
That
is
is-
very,
that is
law is,
clear.
I think that will be prejudiced to the petition, my lord. Only
We
the,
cannot make such observation.
That-
but
yes,
then-
that's what.
Then that will.
But it is,
Okay.
It depends on the department, whether they want to again proceed, that is a different issue, but then our concern is on the suspension order, and the suspension order has not been extended and it is invalid. And you, I think, no, there should be not more than that direction, you will say.
This petition. Or this writ petition under Article 226 of the Constitution of India has been filed by the petition. Challenging. Where is the suspension order?
Suspension order is in page 17.
Okay, this is. Okay, thereafter, no any other order. Review order, okay.
Yes, on the afternoon order.
Yes. Then after hearing, heard, Mr. and Mr. to whom Lion Standing Council for the Education Department, stop. Para, the petitioner who was serving as
BEO,
DEO.
Block Education Officer.
Education.
Okay. DEO, okay, block
Education Officer.
education officer under in the office of the Deputy Director of School Education, Lohit. Has been placed under suspension. By an order dated 11. It's 11 or not 11?
It is,
Issued in 28.
28, yes, the down,
Okay, 11,
right side.
11/8/2020,
issued on 20th August.
2024. Communicated on 28/8/2024 with immediate effect. On the ground that the ground for suspension is that the petitioner was involved in the illegal appointment in the education department during his tenure as BEO in Anjo district. Stop. The further allegation against the petitioner is that in his capacity as BEO, he had arranged illegal appointment of petitioners, illegal appointment of illegal appointment of the person, his nephew, Sri Hamso Ngadong, with the help of broker Sri Taba Pinka and through Sri Midak Riba, the then BDAC Anjo district, and that the petitioner have involvement in the illegal appointment of PRPs and MTS during the petitioner's tenure as BEO under Sri Midak Riba DDAC Anjo, against whom the case has been registered. Sorry, registered as SIC VIJ case number 04/2023 under section 120B /420 /468 /471 /409 IPC, read with section 13 within bracket 2 PC Act 1988. Stop. Huh? Yeah. The grievance of the petitioner is that after placing him under suspension by the aforesaid order dated 28/8/2024. 28 and 20, it's 20 only, not 28, huh?
20 is.
Hmm. No, just a minute. Huh? The grievance of the petitioner is as per the Rule 10(6) of the CCS Rules 1965. The authority is to review the order of suspension. You read the book. Just a minute. Where have you quoted the rules? Have you quoted?
After the rules, nothing should be in para 3.
And 6 of the CCS rule, sorry, it is contained at that. Rule, as per the rule 10(6) of the CCS Rule 1965 provides for review of the order of the suspension by the authority competent to modify or revoke the suspension before the expiry of 90 days from the effective date of suspension. Stop. However, in the present case, the petitioner's suspension order was not reviewed, although he has been under suspension for for about how many days by now? 167 days at the time of filing this, till the filing of this writ petition. Stop.
Para 10 also, my lord. Rules are in para 10 also. Rule 10, sub clause 7. Page 12. Page 12, other rule 10, sub clause 7.
Accordingly, the petitioner filed this writ petition seeking setting aside and quashing the impugned suspension order number same dated 28/2024 issued by the Commissioner of Education, Government of Arunachal Pradesh. For violation of the Rule 10(6) and 7 of the CCA rules 1967, 65. Stop. The petitioner, the subsistence allowance, where have you stated regarding subsistence allowance?
Subsistence allowance, yes. I have
The-
stated in
Okay. The and continue and for revocation of the suspension order forthwith, staff. You have not prayed for, I think, for subsistence allowance.
it's
What is being granted,
it is what granted, your lordship.
not granted.
Granted.
Granted,
Yes,
then it not required.
yes.
Okay. The Mr. Tobum Lani Standing Council was directed to obtain. By which order it was directed?
By order dated, my lord, 31/07/2025, my lord.
Okay.
31 July 2025.
Mr. T. Tobum Lani Standing Council for the Education Department. On direction. Then I was directed to obtain instruction. Whether okay. 28/3/2020, this was regarding the subsistence allowance. Obtain instruction. In compliance of. Accordingly, compliance affidavits has been filed by the respondent number
1, 2, 3, 4, my lord.
1, 2,
All.
3, and 4. And at 4. Where at para 2. The respondent had stated as follows, reduce this para to page 52, reproduce, this entire. That they say that it has not been reviewed as on date, however, the substances allowances. Okay. Then this conclusion, okay, and this suspension will be revoked, and then we will be
Petition may be
directed at
reinstated.
liberty to post the petitioner in any non-substantive post.
My lord.
Okay.
Right.
Conclusion. Okay.
Obliged.
Then, okay. Yes.
Item number 19.
I'm pressing for interim order. Okay. Although there is as per the previous order, Lordship, if this authority concern has not released this monthly wages of labor. Yes, this petitioner of labor. And suspension is illegal.
Contingency staffs, labor.
Labor, contingency labor.
Contingent labor.
They're suffering. Also, they are working previously. Their monthly wages are released. But then in the middle, that has no. But the authority saying that one MLA has made a complaint to the SCB. Anti-Corruption Bureau, whereas there is no just proceeding against this petitioner before the SIC and SCB.
Lordship,
Notice was issued.
notice was at this stage, it will be little tricky to,
Yeah,
So I am
are you filing affidavit?
yes, Lordship, I'm in receipt of the instruction.
Okay.
on the
Miss-
last occasion,
Hmm.
taking time for.
No, this is.
He's now she has received, okay, Mr. T. Tapak, Lanet Council for the petitioner is present. Miss Riba, Lanet Additional Senior Government Advocate, submits that she has received an instruction and the state is going to file. Say respondent number? State is going to file affidavit.
All the.
All the response.
Okay. So you file within a week?
Lordship, let this be after 4 weeks, Lordship, because once we.
That is
Okay.
why
Receipt and
they can take.
This-
filing for which some more time would be required. Staff prayer allow. List this matter after the ensuing winter vacation, after 3 weeks. Okay.
Because, Lordship, first
Okay.
week,
In the meantime, the state shall file their affidavit in opposition.
No allegation against the petition, right? Saying.
See, if there is no any allegation, why should trouble them?
That is the issue.
They have been discontinued.
Because in a case, where the state has made mistake, allow them also. Certain obtain immediate instruction and then give them, allow them to have the relief. Okay, no point
Yes.
keeping it
The
pending.
next
Okay.
observation may be made on the next, concept over the concept.
No, because they are yet to file affidavit. Let them file thereafter. Okay.
They can file anytime. That is.
So I'm saying that in the meantime, the state shall file their affidavit. Huh?
Interim protection, because I want, this, I have to maintain a family, I'm a laborer,
Yes, yes.
my salary is not since,
You file within 3 weeks, huh?
After
Okay.
discontinuation.
After discontinuation, it will be difficult. When it was discontinued, by the way,
not discontinue, just a hold.
halt.
Yeah.
When it was halt. How many, other
As per the hold.
more matters are there? One, one,
On that,
two,
merge.
two. Are they urgent? Okay. We'll finish it off if it is possible. Okay. Okay. After 3 weeks, huh? In the meantime, they will file. Okay, yes. Item,
Matter, this item number 26 may be adjourned, Lordship, because.
26,
Petitioner, advocate of the petitioner are not here.
26.
Let's.
Okay,
In 26, Your Honor, I am for a respondent, Your respondent number 1.
okay.
Ah.
No, okay, 26, huh?
Matter not adjourned.
Mr. T. Dapa. Lana Council for the, you are for respondent number?
Respondent number 2, I am for a respondent number 1.
Okay, Mr.
Mudang Upo.
M,
Mudang Upo.
M. Oppo, Madam Oppo, Lana Council for the respondent number 1. And Mr. T. Dapa, Lana Council for the respondent number 2 are present. None appears on behalf of the petitioner. On the, in view of the above, the matter stand adjourned. List this matter after 3 weeks. Okay?
God bless you.
And
Item number 20.
20.
I would say otherwise a very short matter. I
Okay.
can finish it within 10-15 minutes. It can be disposed of, my lord.
But then this is-
My lord, before
My lord,
my
here-
senior,
Yes,
page
yes.
86, this is bank authorizations. After authorization, payment has to be made, but earlier PIO, unfortunately, he expired. Now new PIO is being transferred. Now he is taking all charge. I think today or yes, tomorrow he is taking charge. So after taking charge, I think he must release the payment.
Okay, what
My
do we
lord-
do then?
My lord, I'm just shortly indicating what is the matter here. The petitioner was awarded the work order and he continued with the work. The technical bid of one of the participants was rejected. So he filed a writ petition challenging the rejection of his technical bid as well as grant of work order in my favor. Now, during the pendency of the writ petition, there was no stay, so I was continuing with the work.
Okay.
And ultimately, my lord, the writ petition was allowed and rejection of his technical bid was set aside and my work order was also set aside. But the court has made an observation that whatever work I have done, for that, the payment should be made. Page 41, Lordship, may just have a look. Just 2 minutes I'll show, madam. Page 41. Now only the payment for the work I have done is to be made to me, nothing else. And authorization is also there, but that executive engineer died, that is why the payment could not be made. Page 41, my lord.
Okay.
Impugn order dated so and so by which the technical bid of the petition was rejected. Consequently, all consequential action, including the issue of letter of intent and the work order, Lordship has got, my lord.
Yes.
Work order in favor of the respondent number 5, that is the present petitioner, my lord, stand interfered with and are accordingly set aside. The remaining part of the work is to be assessed and same is required to be allotted to L1 bidder who is found eligible in accordance with law. This is important, my lord. It is, however, made clear that so far as the works done by the respondent number 5 in the meantime is concerned, there shall be no restrictions towards payment and release of the bills to be said respondent number 5. So whatever work I have done for that, payment is to be made. Otherwise, my work order has been set aside now. Then, my lord, we preferred a writ appeal.
Okay.
My lord, writ appeal, our writ appeal was dismissed. Lord, will kindly have a look at page 42. We prepared a writ appeal, and in the writ appeal, my lord, there was an interim order. That your lordship will find at page 46, the operative part, my lord. Last paragraph, para 50 minutes. In the meanwhile, the effect and operation of the impugned judgment and order dated 23/5/2005 passed by the learned single judge in WPC shall remain state. So thereafter also we continued to work. Then, my lord, writ appeal was pending. This was an interim order. Then page 47, lordship will find there was a IA, and in the IA, this one court is recorded at page 49, my lord. A report submitted by the superintending engineer as to the extent of work we have already executed. Page 49, last paragraph. We have perused the report submitted by the superintending engineer, Rural Works Circle, which indicates that the overall achievement in percentage of work is 59.79%. So, after that, my lord, the writ appeal was dismissed. So, after the dismissal of the writ appeal, my lord, whatever work I have done, I am entitled to get the payment, my lord. Now, lord, will kindly see just page, my lord, 64, my lord. For the work I have done, there are two bills. One is of 7,79,63,546 at page 64. Enclosed, please find here with requisition of bank authorization under PWD Changtajo after necessary recommendation for the VBIP road works as per follows. So this sanction also is there. The superintending engineer has already informed the empowered committee. And then lordship will find at page 66, the second bill that is also there for 4.44 crore. Now, in the meantime, that incident happened, my lord, and the state is aware of that incident where the executive engineer possibly committed suicide allegedly. So for that, the further process could not be undertaken, and I did not get the amount. So my this petition I filed only for a direction to the respondent. My learned friend is also indicating that the executive engineer has now joined. He was not there, so payment could not be made. Now he has joined. I think Mr. Learned Counsel appearing for the state is saying. So lordship will simply direct that to make the payment as soon as possible, my lord. Because bank authorization is also there. Amount is also sanctioned.
Yes.
Everything is over.
Yes, Mr. Tarak.
4 rupees, 7 crore 79 lakhs, that is page 86.
Okay.
Since bank authorization made after completing all the formalities, now only they have to release, PIO has to release the payment.
Okay.
Now, since PIO has been now joined, so he was not released from the earlier posting because of this election. Now, after election process, he will join there. Then I think he will release the payment.
So then what
Lordship will record my learned friend's submission and Lordship will give them in sometime, say 15 days time to release the amount.
Time has to be given.
time?
Yeah.
My
Okay.
lord.
Otherwise, from respondent number, that is, there is no
All-
issue with respondent 1, 2, 3.
Only 4 and 5,
4
I
has
think.
to release the payment. 4 has to release the payment.
Lordship will direct all the respondents to make the payment. For the remaining part of the work, my lord, the government has entrusted another contractor, so I am not there, my lord. Only these two bills are pending, and in terms of the order passed by the Supreme Court, I am entitled, and there is no writ appeal against that single judge judgment, that part of the order, my lord. So Lordship will direct the respondents to release the amount
Just.
within a period of 1 month. इसे तो हम दियो पूरे आराम से कहो फोटो लगी मिल जाओ कि आपकी एपिसोड दे दो and in the synopsis I have given these in short my grievance manner. What about the dollar basket? कोई नहीं report by the basket. So that too really
My lord, page 86, that is bank authorization. Name of the PIO is also given, but now since earlier PIO expire, now it made new PIO name may also indicated. So this may require re-bank authorizations. So if the name is not mentioned, then there could no issue. Page 86, name of the PIO.
PIO.
Name is mentioned there.
PIO.
Yes,
Page 86.
86. This is bank
So
authorization.
PIO is at where?
Here, name of the PIO. Now, after his expire, now new PIO.
Here, Lik Wang
Lik Kwang, yes. Now he is no more.
is no
Now
more.
new PIO will come. His name may change.
So name is to be mentioned.
Yes, the here name is mentioned.
No, whether the name is to be mentioned.
I
in the
think it
order.
has to be mentioned.
Name of the PIU is to be mentioned.
Yes.
My lord, these are internal matters of the department. Lordship will simply direct that the bills of the petitioner which are pending that may be paid within a time frame, because this honorable court need not enter into the internal matters of the department.
Yes.
They will do all the formalities of giving the name of new PIO, etc. Lordship will simply direct that sanction is already there, verified, everything is done.
In that case, 2 week time maybe, within 2 weeks.
Within?
Direction may given to the PIO to release the payment within 2 weeks.
Okay. PIU is the respondent number?
4.
4 by. PIO, no? It is, in fact, it is the executive engineer who is the PIO. So now new executive engineer will do it.
What is the total amount to be released?
My lord, total amount, these two bills are there, so it is altogether it comes to 12 12 from at page 13 we have given. Page 13, my lord, of our petition.
The bank authorization of 7 crore 79 lakhs, page 86.
My lord, there are two bill. One is for 7 crore 7963 lakhs, so, and the second is 4,44,073. Total is 12 crore 24 lakhs 37,543. And we have maintained here, Lord, will see both bills were duly verified and forwarded by the superintending engineer Rupa Circle to the empowered officer ARRDA for authorization. That despite such verification and recommendations, the corresponding authorities have withheld payment without any lawful justification, and thereby causing grave financial hardship. So Lordship will direct them to release these amounts at the earliest within 2 weeks. My learned friend is saying no difficulty. And their document, Lordship will refer to their document, department's document, page 66 and page 64, my lord.
Page 66.
And 64 and 66. 64 is for that 7 crore 79 lakhs and odd, and 66 is for 4 crore 44 lakhs and odd. There is no dispute about the payment, my lord. Only thing is that that gentleman died by suicide, I am told. My learned friend will confirm that.
Okay.
Lord may pass the order.
These two amounts are sanctioned already. Violation under the BE.
My instruction is so far as 7 crore 79 lakhs and odd is concerned, that is already sanctioned. And the sanction for the other 4.4 crore, 44 crore, that is, I think, is in process.
In process.
My lord, I am
Then
told.
direction to release these 4.44 crore.
Yes.
The
My
seven,
lord, so far, my learned friend will be in a better position to say more, but otherwise my submission will be, so far as the first bill is concerned, Lordship will direct them to make the payment within 2 weeks. So far as the second one is concerned, Lordship may direct that whatever formalities they have to do, they will do it, and they will release it within 1 month. Paragraph 25 of the petition may kindly be seen for a moment at page 14. I have mentioned all these things about sanction, etc. Page 14, para 25. This will clarify everything, madam. I'm sorry to detain your lordship, madam. It's already 1 o'clock. Para 25, lordship has got, madam, page 14. That further it is to be stated herein that pursuant to the submission of the bills amounting to rupees 7.79 crore and rupees so respectively, for the bill amount of rupees, for the bill amount of rupees 7 crore 79 lakhs and odd, the authorities have already approved the bill amount and got the amount sanctioned for disbursal from the concerned bank. Thus, the bill amounting to be so is ready for disbursal and is lying in the concerned RWD DPIU 2 division. But the same has not been disbursed to the petitioner's account till date. However, in respect of the bill amounting for rupees 4 crore 44 lakhs, etc., although the same is also approved, but the sanction from the bank is pending. Therefore, there is no dispute with regard to the completion of work for which the aforesaid 2 bills have been approved by the respondent authorities. So this is the status, my lord. Lordship will direct that 7 crore 17 lakhs they should immediately release, and for the 4 crore 44 lakhs, the formalities that are required to be done from the bank, they will complete because the department has already approved. They will obtain the
That you can
sanction.
do. Okay, Mr. D. Mojumdar, the Senior Counsel, assisted by Mr.
P. Bora,
P. Bora, my lord.
P. Bora. learned counsel for the petitioner. I've also heard Mr. G. Tarak, learned counsel. It's a standing counsel for RWD.
Yes.
Learned standing counsel for RWD, representing all the respondents.
My lord, is your lordship
I'll
sitting
pass.
at 2 o'clock today?
No. So
Then
that
your
is why.
lordship can pass the order in the chamber also. It's not, I should not
Yes.
detain your lordship.
Okay.
My lord.
Okay.
My lord, my lord. I'm
Okay,
sorry to
yes.
detain your lordship, my lord.
Okay, finish chamber.
Oh,
Oblige, my lord.
इसको भी ला दो।